Look at you, thinking you can pull me over. You don't even deserve that badge. I run this road, officer. I'm a judge, and I decide who goes where. If you joke with me, I'll make sure you spend the night in jail. You hear me?
Sir, I stopped you because you were speeding. Your position doesn't place you above the law. I need your license.
Officer Daniel Carter was doing routine patrol on a state highway at 10 in the morning on a sunny Friday when he saw a white SUV pass him at a speed his radar registered at 88 miles per hour in a 65 zone. Daniel had been a state police officer for 8 years, had an impeccable performance review, and took his job seriously, but with the professional calm that came from experience. He turned on his lights, briefly activated the siren, and accelerated to catch up with the offending vehicle. The SUV took an unusually long time to pull over, continuing its speed for almost a mile before finally slowing down and stopping on the wide shoulder of the rural highway. Daniel parked his patrol car behind the SUV, checked the plate in the system as he approached, and saw it was registered to a man named Richard Thornton. Nothing unusual appeared in the check. No warrants, no alerts, just a routine traffic stop for speeding. Daniel approached the driver's side, noting through the rear window that the driver appeared to be a middle-aged white man. When he reached the driver's window, Daniel knocked politely and waited for the driver to lower the glass. What he saw when the window came down was a man in his 60s, gray hair perfectly combed, wearing a navy blue polo shirt and expensive sunglasses. Daniel followed protocol exactly as he always did. He identified himself as Officer Carter of the State Highway Patrol, explained he had stopped the vehicle for speeding, and politely asked for driver's license and vehicle registration. The man in the SUV didn't respond immediately. Instead, he slowly removed his sunglasses, revealing eyes Daniel immediately recognized as hostile. The man looked Daniel up and down in a way that was unmistakably disdainful, his eyes lingering on Daniel's black face with an expression that communicated contempt without needing words. Then he spoke, and his tone matched the expression. He asked if Daniel knew who he was. Daniel had heard that line many times over the years. It was what people with some measure of power or status said when they thought they should be immune to laws that applied to everyone else. He responded politely that no, he didn't know who the driver was, but that he still needed to see driver's license and vehicle registration regardless. The man let out a short, humorless laugh. He said he was Judge Richard Thornton of the County District Court, that he had served on the bench for 23 years, and that Daniel should be very careful about how he proceeded. The implication was clear. It was a barely disguised threat from someone used to his title-carrying weight and commanding deference. Daniel kept his expression neutral and professional. He said respectfully that he understood the driver was a judge, but that everyone was subject to traffic laws and that he still needed to see the requested documents. He said this with the same polite calm he used with all drivers, without condescension, without attitude, just straightforward professionalism. But Judge Thornton clearly wasn't used to being treated like anyone else. His expression hardened. He said he was in a hurry to get to court for an important hearing, that he was only a few miles over the speed limit, and that Daniel was wasting his time with nonsense. He still hadn't provided his driver's license or registration. Daniel breathed deeply internally, feeling the familiar tension that came when a routine stop began to unnecessarily complicate. He repeated, still politely but more firmly, that he needed the documents, that if Judge Thornton was late, this would only take a few minutes if he cooperated, that the faster he provided the documents, the faster the stop would end. But Thornton wasn't interested in cooperation. Instead, he did something Daniel had experienced before, but that never ceased to shock by its brazen audacity. The judge pointed his finger directly at Daniel's face and said loudly and clearly that Daniel didn't even deserve to wear that badge, that he was a disgrace to the uniform, that officers like him were the problem with law enforcement today. Daniel remained completely calm, though inside he felt the familiar mixture of anger and resignation. He had heard variations of this type of insult before, usually from people who couldn't directly articulate their racism, but made it clear through vague attacks on his competence or character. He asked Judge Thornton calmly what specifically about him suggested he didn't deserve his badge. He was doing his job within proper protocol. He had been polite and professional. So, what exactly was the problem? Thornton didn't answer the question directly. Instead, He said Daniel was being insubordinate, that he was questioning a judge, and that there were ways to deal with officers who didn't show appropriate respect. Daniel felt the situation slipping into dangerous territory. He discreetly turned on the body camera on his chest, ensuring it was recording, then said clearly he was being completely respectful, that he was simply performing his legal duties, and that asking for documents during a traffic stop wasn't insubordination. It was standard procedure applied to all drivers regardless of who they were. Thornton saw Daniel activate the body camera, and his expression changed from disdain to something closer to fury. He said Daniel had no permission to record him, that it was an invasion of privacy, and that he demanded Daniel turn off the camera immediately. Daniel calmly explained body cameras were department policy during all public interactions, and that he was within his rights and obligations to record it. That's when Thornton really lost control. He began yelling, his face turning red, veins bulging in his forehead. He said he wasn't going to be intimidated by some rookie officer who clearly didn't know who he was dealing with, that Daniel was going to regret stopping him, was going to regret treating him with disrespect, was going to find out exactly how connected he was in the system. Each word came out with increasing volume and venom. Daniel noticed passing traffic was slowing down, other drivers looking at the scene, some potentially recording on their phones. He tried to de-escalate. He told Judge Thornton if he would simply provide his documents, Daniel would process the speeding citation and they could both go their ways, that there was no need to turn this into a bigger situation than it needed to be. But Thornton was beyond reasoning now. He got out of the SUV, despite Daniel not asking him to do so, violating basic traffic stop procedure. Daniel immediately went on alert, his hand moving instinctively closer to his belt, not to his weapon, but to his radio. He told Thornton to please return to his vehicle, that exiting during a traffic stop without being instructed was unsafe and unnecessary. Thornton completely ignored the instruction. He marched until he was inches from Daniel, invading his personal space in a way that was clearly intimidation. Thornton was a few inches shorter than Daniel, but tried to compensate with physical aggression and volume. He yelled that Daniel wasn't going to tell him what to do, that as a judge, he understood the law better than some cop, and that he was going to personally ensure Daniel was fired. Daniel stepped back, creating distance, keeping his body language non-threatening but firm. He said in a clear voice that if Thornton didn't return to his vehicle immediately, the situation would escalate beyond a simple traffic citation to possible obstruction and contempt. That Daniel didn't want to have to make that call, but that Thornton needed to follow legal instructions. The threat of additional charges seemed to penetrate Thornton's anger for a moment. He hesitated, then returned to the SUV, but left the driver's door open and continued yelling from inside the vehicle. He said Daniel clearly had something against him personally, that this was targeted harassment, that black officers always had inferiority complexes that made them attack successful people. There it was. The mask had finally fallen completely. Thornton had said out loud what had been implicit since the beginning of the stop. This wasn't about traffic stop procedure. It wasn't about speeding or about respect for judicial authority. It was about race. It had always been about race. Thornton saw Daniel as inferior because of the color of his skin, and the fact Daniel was in a position of authority over him at this moment was intolerable to Thornton's worldview. Daniel felt that familiar mixture of exhaustion and determination. Exhaustion because he had lived variations of this same scene many times. Determination because this time there were cameras recording, there were witnesses, and there were consequences available that didn't always exist before. Daniel spoke directly to his body camera, establishing a clear record for any future review. He said at 10:17 in the morning on a Friday, he had stopped a vehicle for speeding, that the driver had identified himself as Judge Richard Thornton, and that the judge had refused to provide documentation, had exited his vehicle against instructions, and had made multiple statements disparaging Daniel's authority and making comments about race. That all of this was being recorded both on body camera and potentially by witnesses. Thornton heard Daniel narrating for the camera and became even more furious. He said Daniel was creating a false narrative, that he was distorting the situation, that he was trying to make Thornton look like a racist when he clearly wasn't. Another vehicle stopped behind Daniel's patrol car. It was a Second State Highway Patrol officer, Officer Lisa Morgan, who had heard Daniel's stop over the radio and decided to check if he needed backup. Morgan was a 15-year veteran, known for her solid judgment and calm temperament. She approached the scene, immediately assessing the tension in the air. Daniel briefly summarized the situation for Morgan: speeding, refusal of documentation, combative behavior, inappropriate comments about race. Morgan nodded and approached the SUV where Thornton was still sitting with the door open. She introduced herself and politely asked Thornton to provide his driver's license and vehicle registration. Maybe he would respond better to a white officer, Daniel thought with bitter irony. But Thornton wasn't in a place where rationality or self-preservation were working. He told Morgan she was making a mistake by supporting Daniel, that as senior officer she should recognize her colleague was clearly out of line. Morgan responded calmly that she had reviewed the situation and that Officer Carter had followed appropriate protocol, that the stop was legitimate, and that Thornton's refusal to cooperate was only prolonging what should have been a simple interaction. She again asked for the documents. Thornton looked between the two officers, clearly realizing Morgan wasn't going to take his side simply because he was a judge. He finally, reluctantly, grabbed his wallet from the center console and handed it to Morgan, not to Daniel. Morgan passed the wallet to Daniel, who took it back to his patrol car to process the citation. While he was there filling out the paperwork, he could see Morgan talking with Thornton, trying to calm him down, explaining that resisting a traffic stop only made things worse. Daniel completed the citation, checked Thornton's driving history in the system, noticed he had 2 previous speeding citations in the past 3 years. This wasn't just a lapse in judgment, it was a pattern of behavior. Daniel returned to the SUV and politely handed the citation to Thornton along with his license and registration. He explained Thornton had 30 days to pay the fine or contest in traffic court, and that driving safely in the future would avoid this type of situation. Thornton took the documents but wasn't finished. He looked directly at Daniel's body camera and made a statement that would be replayed millions of times in the following weeks. He said this wasn't over, that as district judge, he had significant influence over law enforcement promotions and budgets in the county. That he was going to personally ensure Daniel's career suffered for this humiliation. That Daniel was going to find out there were consequences for not showing appropriate respect to those in positions of judicial authority. Every word was captured in crystal clear audio with timestamp. Direct threats of retaliation from a judge against a police officer for performing his legal duties. Daniel didn't respond to the threats. He simply said Thornton was free to go, to drive safely, and to have a good day. Thornton departed, his SUV accelerating back onto the highway, probably still above the speed limit, though Daniel didn't pursue him this time. Morgan stayed with Daniel while he completed his stop paperwork. She asked if he was okay. Daniel said he was, that he had experienced worse, but that he was tired. Tired of having his competence questioned, tired of having to be twice as professional because any mistake would be magnified, tired of judges and lawyers and people in positions of power thinking rules didn't apply to them. Morgan said she would include everything in her report as a witness, that Thornton's behavior was unacceptable regardless of his title, that Daniel had done everything right and that any review would confirm it. Daniel returned to the highway patrol station at the end of his shift and immediately went to speak with his supervisor, Captain James Rodriguez. He reported the entire interaction with Judge Thornton, handed over a copy of the body camera recording, and mentioned the retaliation threats Thornton had made. Rodriguez watched the recording twice, his expression becoming increasingly serious. He told Daniel he had done everything correctly, that the stop was justified, that his behavior was exemplary under provocative circumstances, and that Thornton's threats were extremely problematic. Rodriguez said he would forward this to Internal Affairs and to the State Attorney General's office because a judge threatening an officer for performing his legal duties was potential corruption and abuse of judicial power. But before Rodriguez could officially initiate that process, the story leaked. One of the drivers who had passed during the stop had recorded part of the interaction on his cell phone and posted it on social media that evening with the caption, "Judge loses it on cop during traffic stop." The video showed Thornton yelling at Daniel, exiting his vehicle, invading Daniel's personal space, and making the comments about black officers having inferiority complexes. It didn't show everything, but it showed enough. The video began to spread. Within 12 hours, it had 500,000 views. Within 24 hours, it was being covered by local news stations. Within 48 hours, it was on national news. Journalists began investigating. They discovered Judge Richard Thornton had 23 years on the bench, that he handled criminal and civil cases, and that he had a reputation in the legal community as someone difficult and sometimes hostile. Lawyers spoke anonymously about how Thornton seemed to have different standards for defendants depending on their race, though nothing had been formally proven. Stories began emerging from people who had appeared in Thornton's court and felt they had been treated unfairly. A black man who had received 30 days in jail for contempt of court for simply questioning a decision. A Latina woman who felt Thornton had been excessively harsh in her sentencing for a minor crime. Patterns began to emerge. The State Judicial Conduct Commission, responsible for overseeing judges, announced it was opening a formal investigation into Thornton's behavior. Civil rights organizations called for his immediate removal from the bench. The local bar association issued a statement saying it was reviewing whether to recommend disciplinary proceedings. Thornton initially tried to do damage control. He issued a statement through his lawyer saying the situation had been misinterpreted, that he was having a stressful day, that he had always respected law enforcement, and that he regretted if his words had offended anyone. The statement was met with massive skepticism. People pointed out the video didn't show someone having a stressful day. It showed someone revealing their true attitudes. Daniel was contacted by multiple organizations offering support. The local NAACP offered to provide legal resources if he wanted to file a civil action. The police union, which had a mixed history on racial issues, this time stood firmly behind Daniel, issuing a strong statement condemning Thornton's threats and calling for full accountability. Daniel gave a single press conference at the Highway Patrol office with Captain Rodriguez beside him. He spoke calmly and professionally. He said he had simply done his job, that he treated all drivers equally regardless of their position or race, and that no one was above the law. That Thornton's retaliation threats were not just directed at him personally, but represented a threat to every officer who might hesitate to do their job for fear of political consequences. Public reaction was overwhelmingly favorable to Daniel. Social media comments praised his professionalism under pressure. People shared their own stories of encounters with Judge Thornton, building a public record of problematic behavior. Petitions circulated calling for Thornton's removal, gathering tens of thousands of signatures. The district court chief judge was forced to issue a statement saying the behavior shown in the video didn't represent the judiciary's values and that the investigation was being taken seriously. Thornton was placed on administrative leave while the review proceeded, meaning he no longer presided over cases but still received his full judicial salary of $190,000 annually. The Judicial Conduct Commission's investigation expanded beyond the traffic stop incident. Investigators began reviewing Thornton's judicial decisions over the past 10 years, looking for patterns of racial disparity in sentencing and rulings. What they found was statistically significant and disturbing. Black defendants who appeared in Thornton's court received sentences on average 37% longer than white defendants for comparable crimes with similar circumstances. He denied bail to defendants of color at a rate 62% higher than white defendants. He upheld contempt of court charges against black and Latino defendants at a rate 5 times higher than white defendants. The numbers were so glaring it was impossible to explain them as coincidence or legitimate differences in case circumstances. Criminal defense attorneys who had practiced in Thornton's court for years began speaking publicly. A public defender named Marcus Thompson shared he had for years felt his black clients were treated more harshly by Thornton, but hadn't had the resources or data to formally prove it. He said he had learned to avoid certain defense strategies in Thornton's court that worked with other judges because Thornton seemed to interpret them as disrespectful when they came from attorneys of color defending clients of color. Another attorney, Sarah Chen, described an occasion where Thornton had commented she spoke English very well, assuming she wasn't born in the United States when she was actually third generation from California. small moments of prejudice that accumulated into a pattern of behavior. The complete body camera recording was released publicly after Daniel gave permission. It lasted 23 minutes and showed the entire incident from beginning to end in painful detail. Media replayed specific parts repeatedly. Thornton saying Daniel didn't deserve his badge, Thornton making the comment about black officers having inferiority complexes, Thornton threatening to use his judicial influence to harm Daniel's career. Legal experts appeared on news programs explaining how Thornton's threats potentially constituted official misconduct, abuse of power, and possibly even obstruction of justice. Some argued there should be criminal charges, not just judicial disciplinary proceedings. The state attorney general's office opened its own separate investigation, focusing specifically on Thornton's retaliation threats. Investigators interviewed law enforcement officers throughout the county, asking if any of them had experienced or witnessed inappropriate pressure from Thornton. 3 officers came forward with similar stories. One described how Thornton had issued a questionable arrest warrant against a suspect an officer had witnessed not committing the crime, and when the officer tried to present exonerating evidence, Thornton threatened him with perjury charges. Another talked about how Thornton had used his position on the Judicial Budget Committee to threaten to reduce funding for police departments he felt didn't show appropriate respect to the judiciary. A pattern of abuse of power was emerging that went far beyond a single bad traffic stop. Daniel continued working his regular shift, though he was now recognized wherever he went. People stopped him to thank him for standing his ground. Other officers expressed support, though some muttered he had made their lives more difficult by not simply letting the judge go with a warning. Daniel ignored the critics. He knew he had done the right thing, that treating someone differently because of their title or position was exactly the kind of corruption that destroyed public trust in institutions. If judges were above traffic laws, what else were they above? If officers could be intimidated not to enforce the law equally, what was the point of law? 6 weeks after the incident, the Judicial Conduct Commission issued its findings. They determined Judge Thornton had violated multiple canons of the Judicial Code of Conduct. He had demonstrated bias or prejudice based on race. He had abused the prestige of his judicial office. He had engaged in conduct that undermined the integrity and impartiality of the judiciary. The commission recommended permanent removal from the bench. The recommendation went to the state Supreme Court for final decision. Thornton hired one of the state's most expensive defense attorneys and vowed to fight the removal, claiming the investigation was politically motivated and that he was being scapegoated for broader cultural climate. But his defense was weak in the face of video evidence and statistical data about his disproportionate sentencing. The state Supreme Court reviewed the case for 3 months, an unusually fast process for judicial removal that typically took years. But the evidence was so clear and the implications so serious that the court prioritized the review. Thornton filed briefs arguing he had served with distinction for over 2 decades, that a single misinterpreted incident shouldn't destroy an entire career, and that statistical data on sentencing didn't prove bias, but simply reflected differences in individual case circumstances. His lawyers tried to argue Thornton was having a justifiable reaction to what he perceived as disrespect, not demonstrating racism. But the court wasn't persuaded. The state Supreme Court's unanimous decision was issued on a Tuesday afternoon. In a 32-page opinion, the court agreed with every finding of the Judicial Conduct Commission. They wrote that Thornton's behavior during the traffic stop wasn't an isolated lapse, but part of a demonstrable pattern of racial bias that had permeated his judicial decisions for years, that his retaliation threats against Officer Carter constituted grave abuse of judicial authority, that public trust in the judiciary required judges maintain the highest standards of impartiality and dignity, standards Thornton had repeatedly violated. Judge Richard Thornton was permanently removed from the bench, his legal license revoked, and barred from practicing law in the state. 23 years of judicial career ended. Thornton issued a final statement through his lawyer expressing disappointment with the decision, maintaining he had been treated unfairly, and wishing the judiciary luck. There was no apology to Daniel, no acknowledgement of the hundreds of defendants he may have unfairly sentenced, just self-pity and continued refusal to accept responsibility. Some commentators expressed sympathy, saying a man's entire career had been destroyed by a few minutes of bad judgment. But most people recognized it wasn't a few minutes that destroyed Thornton. It was years of biased behavior that was finally captured on video in an era where such actions could no longer be hidden or denied. Daniel was promoted to sergeant 6 months after the incident, a promotion his superiors said was based on his consistently excellent performance over the years, not just the Thornton case. But everyone knew the promotion was also a statement. The department was saying that officers who did the right things, who maintained their professionalism in the face of provocation, who treated everyone equally regardless of position or power, would be recognized and advanced. Daniel accepted the promotion, but remained humble. He said in interviews he wasn't a hero, he had just done his job. That the real problem wasn't one bad judge, but systems that allowed such people to operate without accountability for so long. Daniel's story inspired changes beyond just removing one judge. The state legislature passed new legislation requiring collection and publication of judicial sentencing data disaggregated by race to identify patterns of disparity. Mandatory implicit bias training programs were implemented for all judges. A new review panel was created to investigate complaints against judges more rigorously. And perhaps most importantly, hundreds of cases of people sentenced by Thornton were reopened for review to determine if bias had affected their sentences. At least 37 people had sentences reduced or cases entirely overturned after review. Marcus, the black man who had received 30 days for contempt in Thornton's court for questioning a decision, was one of those who had his record cleared. He gave an interview saying he had carried that conviction as shame for years, feeling the system was unfair but not having resources to fight back. Seeing Thornton finally held accountable gave him some closure. He said he wished he had had the courage to speak up at the time, but understood why victims of judicial bias often stayed silent. When the person with power to jail you demonstrates prejudice, what recourse do you have? Daniel's case proved that documentation, evidence, and public pressure could create accountability even for the powerful. The body camera recording became training material in police academies across the country. Instructors used it to teach officers how to maintain professionalism under pressure, how to properly handle threats and intimidation, and why documentation through body cameras was crucial. The recording was also used in law schools to teach about judicial ethics and the consequences of bias on the bench. Journalism schools used it to discuss how social media and cell phone cameras had changed accountability in public institutions. What had started as a routine traffic stop had become a case study in multiple disciplines. Thornton disappeared from public life after his removal. Rumors said he had moved out of state, was living off savings and investments, avoided any media attention. Some tried to interview him, but he refused all requests. His legacy was permanently stained. Instead of being remembered for 23 years of judicial service, he would forever be the judge who lost everything because he couldn't control his racism during a traffic stop. A lifetime of work erased by 23 minutes of truth captured on camera. Daniel continued serving as sergeant in the State Highway Patrol, mentoring younger officers, emphasizing the importance of treating everyone with dignity and respect. He spoke at law enforcement conferences about how to navigate difficult situations, about why officers of color often faced unique challenges, and about how departments could better support their members. He never regretted his decision to treat Judge Thornton like any other driver. In fact, he saw it as a defining moment that proved principles mattered more than political convenience. Years later, when interviewers asked about that Friday morning on the highway, Daniel always said the same thing, that he hadn't done anything special. He had just followed training, maintained professionalism, and documented everything properly. That the real hero wasn't him, but the body camera technology that didn't allow denial or revision, and the public that refused to accept excuses for prejudice, even from someone in a position of judicial power. That real change came not from one officer doing his job, but from a system finally deciding accountability mattered more than protecting the powerful. The white SUV Thornton was driving that day was eventually sold at auction after he lost multiple civil lawsuits filed by people he had unfairly sentenced. The speeding citation Daniel issued was never paid. Thornton had contested it on principle, but when he was removed from the bench, the traffic case became irrelevant compared to everything else he lost. The $250 fine was nothing compared to the $190,000 annual judicial salary he no longer received, the pension that was significantly reduced due to removal for misconduct, and the civil lawsuit settlements totaling over $1 million. The story of Officer Daniel Carter and Judge Richard Thornton became a defining example of how behavior captured on video could create consequences even for the most powerful. It proved badges and robes didn't make anyone immune to accountability when their actions were clearly documented. It demonstrated a single traffic stop, handled with professionalism and properly documented, could expose years of systemic injustice. And most importantly, it showed that when officers did the right things, even under threat, when systems finally held the powerful accountable, and when the public demanded justice, real change was possible. The words Thornton shouted that day, "You don't even deserve that badge," echoed in ways he never imagined. Because in the end, it was Thornton who didn't deserve to wear his judicial robe. It was Thornton whose career ended in disgrace. And it was Daniel, the officer he had tried to intimidate and threaten, who emerged as an example of exactly what law enforcement should be. Professional, impartial, courageous in the face of pressure, and committed to the principle that no one is above the law. Not even a judge driving too fast on a highway on a Friday morning.